Good day. Welcome to this YouTube channel. If you have access to my previous videos, kindly like those videos and subscribe to this YouTube channel so that we can upload the more and more videos based on the recent judgments passed by these various honorable courts. So this will also give us the more motivation in uploading the more and more the videos from time to time. So today we are discussing another judgment which has been passed by the Honorable Supreme Court of India on 7th of March 2013. Sorry, 2022. This is a reportable judgment. And before discussing this reportable judgment, the important law point, the legal point was that if there are certain interested witnesses out there, the prosecution case can't be rejected merely on this ground that there are some interested witnesses out there in this case. So if the evidences are very much clear and cogent, and there is no doubt there in the prosecution version, then the appellate courts, especially the high court, should not have to intervene in the version given by the trial court. So this is two criminal appeals which passed by this Honorable Supreme Court of India, and it has been disposed by one common judgment. In this appeal, what happens, the Honorable Supreme Court of India has set aside the acquittal order of two accused number 1 to 3, and restored the version of the Honorable High Court, so in which the several accused number 4 to 11 had been acquitted by the trial court as well as by this Honorable High Court. So based on the concurrent findings, the Honorable Supreme Court has not intervened in by the exercising the power under Article 136 of the Constitution of India. So before this, we will going to the detailed version of this case. What happened is that there was a common judgment passed by this Honorable High Court, that is on 21st of February 2018, in which the Honorable High Court of the Judicature at the Hyderabad in the state of Telangana, and the Criminal Appeal 611/2011, and the criminal appeal by which High Court has allowed the criminal appeal preferred by the accused number 1 to 3 and has acquitted the original accused, by which the High Court has dismissed the criminal appeal preferred by the original complainant, in which the complainant has challenging the judgment and order passed by the trial court. The rest of the accused number 4 to 11, and this based on the common judgment, they have preferred an appeal, which is bearing on this number 72 to 73. So it means there are total number of 11 accused are there, and the trial court has convicted the accused number 1 to 3 and acquitted the accused number 4 to 11. But the High Court, on the basis of the appeal filed by the accused number 1 to 3, they have also acquitted the accused number 1 and 3. So all the accused get acquitted. So based on these judgments, the two criminal appeals filed by the complainant, and it was disposed on 7th of March 2022. So what happened was that, now kindly we proceed further slowly, and says that state has preferred an appeal, the criminal appeals 74 of 2022. It means the 3 accused were acquitted and the state has preferred an appeal as per the prosecution. Now this is the prosecution theory. The prosecution theory was that on 18th of January 2007 at 8:30 p.m. all accused formed a common assembly armed with certain sickles and came behind from the vehicle where the victims were traveling and surrounded the deceased and his brother, who was deposed as the PW1, and other supporters PW3, PW7, and PW8, and there was a driver was there. PW6 was the driver. Then accused 1 to 3 forcibly opened the door and dragged out the deceased, and they hacked him with some sticks and indiscriminately. Accused 8 to 11 hits the sumo vehicles, hunting the sickles and broke the glasses. Accused 9 to 11 hacked the driver PW6 and sustained bleeding injuries on his right shoulder. And these are the version which was there in the FIR. In the prosecution's theory was there. Accused number 4 to 7 chased all the other the witnesses who was traveling there with in the vehicle. So the deceased injury, they caused injuries to PW7, and they all later fled away. The deceased died on the spot, and whereas the PW6 and 7 was taken to the hospital, so and so. So then on the basis of their all accused, a case was registered on the basis of their complaint. Case was registered and all against all the accused during the course of investigations and on of the concerned person witnesses. The investigation agency officer collected the documentary evidences, including the medical evidences. During the course of the investigations, the investigating officer arrested all the accused, and the charges were framed under sections 147, 148, 324, 326, 307, 427, 302, read with 149 of the IPC. So case was trialed by the learned courts of the session. The case was then committed the case to a district and session judge court, Kurnool, where the accused pleaded not guilty, and then they faced the trial before the session court, and all the PW1, PW3 were the eyewitnesses, PW6 were the injured eyewitnesses, and they have made the version that that eyewitness has made the version. The accused number 1 to 3 dragged out the same story which they were there in the prosecution story. They have made they have deposed before this honorable session court, and the same version was given there, and in their depositions, that 8 1 to 3 dragged out the deceased, and accused 8 to 11 hit the glass windows of the sumo vehicle. Accused 9 to 11 tackled the driver, and this causes the sustained bleedable injuries on his shoulders. Accused 4 to 7 chased all the witnesses, and after the prosecution, after the closure of the prosecution witnesses, the statements of the accused was also been recorded under section 1313 of the CRPC, and they have made their version that they have been falsely implicated because of their some political rivalry and the past enmity. So, but they did not lead any evidences and to support their case. And now the court, after the appreciation of the evidences, and found that the accused number 1 to 3 were guilty of the offences, and they were charged, they were punished and found guilty of the offences punishable under section 148 to 302 of the IPC, and sentenced them to undergo life imprisonment of the offences, and 1 year for the offence under section 148 of the IPC, and all accused 4 to 11 were exonerated, where they were acquitted from all the charges. So they all accused, they 1 to 3 were dissatisfied with the judgment. They preferred an appeal before the Honorable High Court, and the case was registered. And now the High Court allowed the criminal appeal preferred by the accused, so means that all the accused got acquitted, and they has also dismissed the criminal appeal preferred by the complainant, who have challenged the acquittal order of the accused, who were 4 to 11. So means there were 2 courts have given the version in the favor of accused number 4 to 11. Trial court has also acquitted the accused, as well as the Court of Session also have acquitted all the accused number 4 to 11. But the High Court has reversed the conviction and set aside the conviction and also acquitted the accused number 1, 2, 3. So now they dissatisfied with this. They filed. State has now also filed an appeal before the Honorable Supreme Court of India against the acquittal order passed by this Honorable High Court. So the counsel of the complainant, now they have made a version that High Court has unnecessarily given the weightage to the alleged interpolation of the FIR with respect of the time of the lodging of the FIR, which means they have registered that this interpolation of the FIR, they have added this version which was not being raised before the trial court. So this question was neither raised before the trial court, or the question of the interpolation. If any, was put to the investigating officer W2 16 to PW 70. It means the High Court has suo moto considered that there was a delay in lodging of the FIR which was never being raised. Means no question was put there before the investigating officer during the course of the trial. So this was one of the ground which was raised before the Honorable Supreme Court of India, that this was the alleged interpolation of the time was asked. No such question of the alleged interpolation of the time was asked before to the investigating officer PW 16 to PW 70. And again, another submission was that High Court has doubted the complaint FIR by merely on the ground that on the ground of alleged interpolation of time, on the ground that there was a delay of 7 hours in lodging of the FIR, and the FIR was sent to the magistrate at 4:30 a.m. on the morning. So this was one of the submission that the High Court has not properly appreciated and considered the facts, and these FIR were sent to the learned magistrate within the period of 24 hours as required by the law. So this was the one. Second version was it, and they have made that High Court has suo moto raised this issue, which has never been framed by the trial court, and it was not the case of the accused before the trial court. So the power, they says that High Court too has to be bounded by the law, as well as if they have to consider this version, that this version was raised there, should have to be raised there before the trial court, but this version was never been raised. So the court has suo moto acted. This was the version. This was the contention raised by the counsel of the complainant, and the prosecution further submission was that the prosecution has already proved the case against 1, 2, 3 by examining all the relevant witnesses. These were the witnesses which were, and the case was being well established before the trial. The High Court ought not have to be interfered with the conviction of the. So there's and further have held that there was some minor contradictions was there, and High Court has also considered these contradictions was not the material contradictions. If one version was given by some witness and another version was given by another witness, if some minor contradictions are there, these are acceptable. But in case there are some major contradictions are there which are having the very materialistic nature of this of the version, so that my major contradictions are always to be considered if the benefit has to be given in the favor of the accused. But and here in this case they said that this was only the minor contradictions. So the High Court, on this basis of the minor contradictions, has doubted the credibility and the trustworthiness of the witnesses, as they are all the interested witnesses. So, and now after this they said that PW5 was also the eyewitnesses, but the High Court has not appreciated PW on the ground that learned trial court has held that PW is not an eyewitness and but a planted witnesses. This was the version. This was the error which was committed by the High Court as per the complainant counsel. So PW5 is the driver, but the court held that it was a planted witnesses. So the appellate court was required to reappreciate the evidences, including the deposition of the PW5. So the discussion was also needs to be done especially if any outcome was coming. So some discussion needs to be done in the judgment, which was not done here in this case. So after this, they said there was no doubt of the credibility and the trustworthiness of the PW6 and PW7. This was the submissions given by the High Court by the counsel. So after this, now we come to the observation which Honorable High Court has held. They said that after hearing the counsels from both the sides, High Court has held the complainant is challenging the accused number 4 to 11 as concerned, and there were the concurrent findings recorded by both the courts. Means trial court has given the same version, has given the version which was also upheld by this Honorable High Court. So accused number 4 to 11 was found to be not guilty, and these findings with respect to the acquittal of the accused are on the appreciation of the evidence on the record. So now the Honorable Supreme Court's powers to have they also did not interfere in by exercising the powers under Articles 136 of the Constitution of India, since both the courts have made the concurrent findings, and they have the Honorable Court has held that the Honorable High Court has already recorded a plausible view, so which was not recorded, which was not required to be interfered by the Honorable Supreme Court Committee. And as far as the appeal is concerned with respect to the acquittal of the accused number 1 to 11, now the court has summarized the discussions made by this Honorable High Court. As far as the acquittal of the accused number 1 to 3 is concerned, they said the FIR was not registered at the time of the prosecution. It was registered many hours of the occurrence and sent to the magistrate with unexplainable delay. This was, and PW3 was the planted witnesses. PW7 could not identify the accused. So they have summarized, the Honorable Supreme Court has summarized the version why they have acquitted the accused number 1 to 3. Now after this, the court has held PW1, PW6, P7, out of which PW1, 3 and 5 were the eyewitnesses, 6, 7 were the injured witnesses. So accused 1 to 3 were also been identified by these witnesses, PW1 to PW3 and 6. The trial court has disbelieved though the trial court had disbelieved the version of PW5, High Court has not discussed, this is a point, High Court has not discussed or reappreciation of the evidences of PW5, which was as a first appellate court, which was required to be. So this is the point the Honorable Supreme Court has held, that if they want to give any version, if they want to make any observation, so they will first have to be discuss the evidences as far as because High Court was the first appellate court here, so there will have to be appreciated the evidences or reappreciated the evidences and may have to make discussions in the judgment. But here the High Court has committed lapse. So, and as far as the PW6 is concerned, and the PW6 has identified the accused number P2W3, and High Court has also observed that there were the planted witnesses, they were all the interested witnesses being the relatives of this. Now this Honorable Supreme Court has held that witnesses or the relatives are deceased, their evidences cannot be discarded solely on this ground. Merely just because they are the interested witnesses, if their evidences are cogent, clear, so their testimony should not have to be discarded merely on this ground just because they were the interested witnesses. So they have committed a material error in discarding the depositions of PW1, 3 and 7. So after discussing this, another portion they have raised that the FIR was sent to the magistrate within 24 hours as required by the CRPC. Merely just some delayness was there. It was not a sufficient ground that FIR there was a delay in the registering of the FIR. Moreover, this point has to be raised there before the trial court, but which was not raised there before the trial court. They said the FIR was registered within 7 hours. As for the prosecution, it was lodged immediately. The interpolation of that incident at 12:30 a.m. to 9:30 p.m. could not be explained as same was not raised before the trial. Because this version has to be raised before the trial, but this was first raised only before the Honorable High Court, and FIR was sent to the magistrate within the 424 hours. They says as per the CRPC, it has to be sent to the magistrate within 24 hours, which was also done here in this case. So delayiness, this was not a sufficient ground that the credibility of the witnesses could be affected, or they have framed the accused. So this was just a minor contradictions were there. If not material in nature, this could can affect the prosecution as a whole. So based on this observation, they have set aside the acquittal order of accused number 1 to 3 and upheld the accused number 4 to 11. So they have the complaint as far as the appeal is concerned with regards to accused number 4 to 11, which was the appeal got dismissed here, but the trial court order of the trial court convicting the accused number 1 to 3 got restored. So I hope you have liked this video. If you have liked this video, kindly subscribe to this YouTube channel so that we can enabling us to post more and more videos more based on the recent judgments passed by this honorable courts. And if you have any queries or doubts based on this video, you are really welcome to post your comments in the comment box, and please do make comments from time to time, and do subscribe to this YouTube channel, and you kindly share this YouTube channel, thank you for giving the valuable time here.